In a medical malpractice case, during a doctor's pretrial question and answer session known as a deposition, is it ever acceptable for me to question the doctor as if I'm cross-examining him as if we were at trial? Would you like to learn the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, I can. You should know that at trial, the doctor whom you have sued is considered a hostile witness when I call him to the witness stand. Technically, even though I'm calling him to the witness stand, I would normally be vouching for any witness that I call to the witness stand. However, in a malpractice case where I am calling the doctor whom you have sued, he is considered an adverse witness. He is also considered to be an expert witness. So because of those two things, I am now permitted to cross-examine this doctor as if he were hostile, which means I get to ask him leading questions, which is great for me. Why? Because now it gives me an opportunity to tell the jury a story through leading questions, and I only want the doctor to answer yes, no, I don't know, or I can't answer. And you should also know, by the way, that when I'm done questioning the doctor, his lawyer, the defense attorney, will then have an opportunity to get up and ask him open-ended questions. So the doctor will then have an opportunity to go ahead and explain as much as possible to the jury. So now, let's go back to the question I raised in the headline. Can I ask the doctor a series of questions during his pretrial question and answer session as if I were cross-examining him at trial? And the answer is yes, I can. Now, why is that? It's because the same rules apply. He's still considered an expert witness. He's still considered a hostile witness. He's an adverse witness to my client. So now I'm going to be asking him leading questions. There will be times, however, where I'm going to ask him an open-ended question. Doctor, tell me why you treated the patient this way. Why did you choose this form of treatment instead of another option? What did you do in this instance? What were you thinking about what your plan of action was? So now there will definitely be times, because I need to know this information for the purposes of trial a year or two down the road. And it's perfectly acceptable for me to ask an open-ended question during this pretrial process. Now, you might think that cross-examination means angry examination. Doctor, why didn't you do this? Doctor, why didn't you do this? Well, let me share something that might be eye-opening for you. Cross-examination does not mean angry examination. I can be very sweet, very pleasant, very polite in the form of asking leading questions. Doctor, isn't it true you graduated from this medical school? Yes. Isn't it true you did your training at this place? Yes. Isn't it true you're board certified? Yes. Now, doctor, isn't it true you saw my client on this day? Yes. Isn't it true she made the following complaint? Yes. And isn't it true you did the following examination? Yes. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you haven't done so yet because you still have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, I do this every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.